And we're off. Welcome to the mysterious world of bond forfeitures. If you've ever wondered what happens when someone skips out on conditions or doesn't follow through, buckle up. This courtroom is about to spill some serious tea.
All right, so this is the bond forfeiture docket, Nisi, case number 24 DCCV 1018, and I guess these are both kind of similar issues with regard to the same bonding consent, correct? And then 24 DCCV 1321. Mr. Kelly or Mr. Romano, what?
Mr. Sullivan, you think we are issue. Thank you. And each Sullivan is team for drug action. One setting, 48 hours.
Translation: the defendant didn't do what the court ordered, get that drug patch. Instead of just losing money on a bond, the real issue here is compliance. Judges don't like excuses, they like results.
Did I? Well, I mean, if it's the But if I had, did you not know about the court date? I mean, regardless of if there's a bond violation, a lot of times what I'll do is, if it comes to my attention through Ms. Werner will get the emails from whoever it is that's supposed to have GPS or a drug patch, and then if I get some type of referral back from them that says either they're not wearing it or they didn't get it or they tested positive, sometimes if it's positive, I'll at that point just raise the bond and do it at large without problem.
Here's the kicker. Test positive and it's not just a slap on the wrist. Judges can yank your bond and leave you sitting in jail. Think of it as the instant consequences button.
If sometimes though, I'll, instead of waiting till the next court date for these violations, I'll move it up a week or two. So I guess if I moved it up, which is what it sounds like for a bond hearing, just a review to see what's going on. Are you saying you didn't know about that date? Uh-huh. Right.
Basically, but you know, they get a problem with what I'm saying. So that one is once again, you hard to up the ball action. I mean, you have to wonder, you know, we're the ones who are trying to keep on cases. So when most of the part of the deal, we don't have much to know about.
18 violations. Let that sink in. Imagine ignoring your probation rules 18 times and still arguing about technicalities. At some point, the court's patience turns into a ticking time bomb.
Yeah.
A couple of things. One, the bond, we want to know what changes have been made here in the courtroom. It's not
Well, let me stop y'all. I think the conversation that we need to have is probably something that we need to have maybe at a bail bond board meeting, where we can address if and how those conditions can be relayed when we do here in court to you guys. But that's the thing, is that's every court does it differently. But the court date and the bond forfeiture, it is what it is. I mean, if they didn't show up, you're not saying you didn't know about the court date. And so I think regardless of why I said something, whether it was because of a bond issue. That's, to me, we're talking about two separate things. Somebody didn't show up for court because of a violation of a bond condition, but they didn't show up for court. So that's a forfeiture. If I know, it's just different on how, it depends on, for me, how I handle it. And we can talk about that later. Mm-hmm.
We had no.
No, I understand that y'all might need some type of, I understand. Well, I don't know that I knew someone violated 18 times. Because, no, I'm just saying I don't know that either of us knew that. Because if someone's violating an ankle monitor 18 times, typically it's going to immediately be at large without proper bond, not just let's reset a hearing for a week out, because I would be concerned about that. So sometimes we may not get it from the company until they say, oh, look, there's been a whole lot of these. And so we don't know that either. So that's obviously something we need to check out. I guess, yeah.
Section 22.2 is not court change in bond conditions. Grounds for exoneration on the bond. It's simply not there. The court has to address the county grant for bond conditions for jail. Right now, Mr. Romano is not told the court they can't go to jail without a condition placed on it at one time. I don't know why they're not getting promised.
Well, no, he's getting them. They're getting them when they're initially done. That's been, yeah, we've been working on that. But what he's not getting is their information here. And I understand that they can't also be in every court every morning. You know, I don't know how many people they have working for them, but we've got 4 or 5 courts going on. So I understand that there's an issue potentially with getting that information. I don't think it changes legally, though, the fact that there was a court date.
And this is where it gets real. Judges don't care about the behind-the-scenes miscommunication. If the defendant didn't show up, that's the end of the story. Forfeiture locked in.
About it, the defendant didn't show up for that court date, and so I don't think legally there's relief necessarily I could get unless there's some agreement with that. I do understand where you're coming from, but I think the fact that y'all knew about the court date, there wasn't some communication issue with knowing that he had to be here. Both of them were guys that they had to be here, and they just didn't show up. I understand what you're saying. If you knew that there were those violations ahead of time, maybe y'all would have filed names for us or whatever. Right. Well, what if you need to talk about that later too? Make a note, because why can't y'all put in your bond agreement that any bond conditions that are there and any bond conditions court orders?
Right now, we're no one's
So were these my conditions on both of these, or were these conditions that were, because I think that is different, these were conditions that were placed by the magistrate at the jail, or were these conditions that were placed on them here in court by me? Okay.
General violation.
Okay, so these weren't the jail issues. Then it's, I'm going to grant the forfeitures in each case, and then we can discuss somehow, if you gotta get with all courts, so figure out a way to get bond conditions that are placed on them after the fact by the courts, which happens all the time. And so I don't know, really, other than y'all being here, but we can try to work something out. But I don't think that necessarily the issue's going to be getting nobody to do with this thing, but we can talk about it all on. All right.
John, just for confrontation or with the extradition notice in the court block, we got it. Case later on.
We'll do so.
And case of judicial notice of the phone call, case to the undefined connection.
We'll do that as well.
And the judgment 42 and 4.
I will do that as well.
Final judgment.
Okay, thank you.
You know.
All right, and hey, remind me, and we'll try to figure this out.
Final verdict, forfeitures granted. But notice how the judge leaves the door open for future fixes. This isn't just about these two cases. It's about how the system communicates, or fails to. Big picture stuff for bail bond companies.